Last name, sir?
Mcdougal.
Okay. All this castle law has come up since September. Tell me a little bit about it and what's going on with it.
Well, and I have to do this in relation to what you're asking me about it for, because we've got two cases that are pending here, or being investigated. Basically, the castle doctrine is not a castle doctrine. It's more of a stand your ground doctrine. And I've got my books here. This is the previous provision for self-defense. This is the new one with the what y'all are calling or what the public is calling the castle doctrine. Castle doctrine basically says, or at least the deadly force in defense of your person is justified, or you're presumed to act reasonably if somebody's trying to enter your home unlawfully or with force. That's the first one. Or unlawfully and with force removes or attempts to remove you, or the other guy's, your house or your vehicle, your place of business. The old law says when you're attacked by a person, number one, deadly force is never justified in response to just force. Is only applicable if you're being attacked with deadly force, then you can use deadly force.
Okay.
And the other provision that played into that was that you're justified to do that if a reasonable person in your situation would not have retreated first. Mm-hmm. Didn't say you had to retreat. Said would a reasonable person have retreated before going to the extreme of using deadly force. That was the qualification on deadly force. The new law, well, I have to go back one more. Okay. It's divided into number one, use of force, and two, use of deadly force. There's two different provisions in the penal code for that. And of course they use the ordinary force, like hitting people, first. And basically the new one says the same thing. You're entitled to use force in response to use of force against you, where you feel it's reasonably necessary to do that. And we're talking about reasonable. So the new provision is that your reasonableness is presumed if this guy's, or the actor is trying to enter your house, your business, or your vehicle unlawfully or with force, whatever that. It's actually entering. It says enter that.
That's entering a structure, though, right?
That's what it says.
Okay, now what if
or is force attempting aggravated kidnapping, sexual assault, that sort of stuff, where you're actually being placed in a position. The new one for deadly force, and before, deadly force was never justified. You had to, without the qualification, would a normal person, would a reasonable person have retreated. This one just says you use reasonable, you have a reasonable belief that you have to use it, and it's immediately necessary to protect you from the other person's use of force, or to prevent the aggravated kidnapping, sexual assault, those kinds of offenses. And further, your belief is presumed to be reasonable if this person is unlawfully and with force entering your house, car, or business, or attempting to commit one of those offenses I previously named. So that section is exactly identical to the non-deadly force provision, which doesn't say the guy's armed, doesn't say anything else. It just says he's entering your house, your car, your business unlawfully or with force. Doesn't say deadly force. And you have no duty to retreat from those
situations.
situations. So,
Now we get, okay, we're saying mainly a building right now. Building, residence, home, vehicle. What about an open area? Field,
No.
yard, house, I mean
no,
just outside.
it doesn't apply to that. It would still apply in my estimation, because we hadn't had one come up. If you're out walking down the street and you get accosted by somebody beating you up, you don't have a right to shoot him.
Okay.
You have a right to defend yourself by hitting him back. If you're being mugged and the guy's got a knife and you happen to have a bigger knife or a gun, then you're justified in shooting him.
If he's got a weapon.
Right.
Okay.
But you're still, and near as I can tell, they've left out the part where it says, let me find it. So this may, I can't find they called it a duty to retreat, but it really wasn't a duty to retreat. It was more of a standard that says, would a reasonable person have retreated? So in the case of a robbery or a mugging or something like that, you're not gonna retreat. I mean,
Right.
that's reasonable. And to be honest with you, in a true self-defense case, there's never an issue of retreating, because the situation's immediate. So I can't think of an example right off the top of my head for.
Okay. Now y'all are working
For
with
that
two
example.
cases right now. You say you really can't
Right.
comment on those, but I mean, say you're standing here, or I walk up to you, start cussing you out, or something like that. You feel threatened. Do you have that right at that point? Can you pull a gun out and shoot me?
No, not the way I read this. The way I read this is, the person you have to number one, be in your house, be in your car, or be in your place of business.
Okay.
Not somebody else's business, your place of business, your house or your car.
Okay.
And the person that you shoot has to be in the process of forcibly trying to get in
All right.
to one of those three spaces that
And
you're
what about
in.
our old, years ago, the old fenced-in yard deal? You know, if you shoot them, they drop outside the yard, drag them back in. The fenced-in yard still considered a dwelling or a property, or how's that considered now?
I can only go, imagine the defense bar will say that's part of the house. I don't think it's part of the house, because this says, I mean, it's clear when it says that he's entering unlawfully with force, your house. If you got a yard and a fence, you're not going to be forcible. I mean, you just walk through a gate or something, and I guess if you tore down the gate or something, but I still think you got to be inside one of those three things: a house,
Okay.
car, or business.
Okay. Now what about, someone just stealing from your property? Just taking something off your property. I walk up, grab your lawnmower.
That is the one everybody's overlooking in all this. And I've already talked to Channel 11. I forgot to put that on there. Did I say Channel 11 on here? Sorry.
Yeah.
I've already talked to them, and it didn't even come up, because so far everybody I've heard from has had some new nuance to put on these two cases. And like I told you before we started this, I intentionally basically don't want to know about the case before I talk to you, so I don't
Right.
get in trouble with the publicity part of that. But as I understand it now, the one that happened over in East County is the guy was stealing from his property, wasn't in his house, did not forcibly enter his house, and that's going to be under Section 9.42 of the Penal Code, which is deadly force to protect property.
Okay.
And basically what that says, there's protection of one's own property. If you're in lawful possession of your property and you can use force against somebody that's stealing to prevent the theft or to terminate that person's trespass on your property.
So if you're actually watching the person, they've got Your property,
and
their
then-
arms,
and then-
walking out your
right.
yard, you can.
You can go accost them. But then the next section says you're justified in using deadly force only if you reasonably believe the deadly force is immediately necessary to prevent the other person's commission of arson, burglary, robbery, aggravated robbery, theft during the nighttime, or criminal mischief during the nighttime.
Okay.
Okay, so if this is a daytime deal,
Right.
and I assume the legislative intent in that is during the daylight you can see the guy's not armed.
Mm-hmm.
At nighttime you got no idea. That's probably the basis for putting nighttime as opposed to any time.
Yeah. Okay.
In the statute. So if the guy wasn't in the commission of arson or burglary or robbery, and it wasn't at night, I don't know that he would have a right to use deadly force.
So something like this, what's this actually turn into? More of a courtroom battle, and of well, the law says this, but the law says this, but the law down here says something else.
I mean, these books I got here are not. The statutes are over there, and they're just as thick as this one book with cases that the Court of Appeals and the Court of Criminal Appeals have decided on all this stuff. So it can get pretty involved as to how the defense witnesses testify and how the state's witnesses testify, because you got to be pretty particular when you. And I guess there's some magic words that have to be said before you're entitled to a jury instruction if you're the defense.
Okay.
If you're the state.
Mm-hmm. Okay. So what they've got. So basically, it's going to end up on something like this, more of a courtroom type thing on which law states what, or what law says whatever, or how does that go then?
That's gonna, and that'll be the way it probably turns out. I would anticipate, because I originally supposed that this one that just happened over there was inside the guy's house. I thought the guy came in.
Mm-hmm.
I didn't realize it was out away from the house in some part of his open property. So that'll cause some. That will, as far as the people want to know about the Castle Doctrine, that's not going to apply to it at all.
Won't apply. Okay. Okay. Now the one Sunday, will that apply at all?
Pardon?
What about the one Sunday? Will that apply at all?
That is closer to it, because there's a couple of things. I don't know if the guy was actually in the house.
Yeah, outside again.
Or outside on the porch, or whether he was being forcible. I mean, every murder case has to be evaluated on its own facts and its own merits, and it's really hard to say what's going to play into a person being indicted or not indicted for a particular offense. So, but I'm sure in both these cases, I would anticipate the people that did the shooting will probably have pretty good lawyers. I don't know. I know they'll have good lawyers if they get one around here. They get one appointed. They do pretty good, and I'm sure that will come up and be an issue for the grand jury when they take it up to consider whether or not to indict either one of these two men.
Okay. What about, I mean, the Pasadena case? I mean, it's not even this county, not even this city. But what's your feeling?
I don't know anything about. I have enough problems keeping up with what happens here. You'd have to give me some facts on Pasadena. But
basically, that one was a guy, a neighbor, watching a neighbor's home being burglarized, calling 911, say, hey, he's being burglarized, I'm going to shoot him. And he built up about a 6-minute 911 call, built himself up to, I'm going to shoot him, and he finally did.
Well, we have a statute on protection of third people's property, and basically you're entitled to use force or deadly force when you can do it to protect your own property. So if this is a burglary at night,
during the day again.
Oh, well, they're actually going in and out of the house. That's gonna be Rosenthal will have fun with that one, or whoever his prosecutor is that ends up doing it. But you do have a right to defend third people's property as well as your own property, as well as defending third people being attacked. I mean, there's a whole bunch of that stuff
No, either
in
way.
the penal code. So
Any idea why this castle law thing came up all of a sudden? I mean, as far as this, what was the intent for this castle law? Do you know where the intent came from on that?
I don't know. I
mean,
really
what
don't. I
also
mean,
they decided, was the language too vague prior to this, or did they decide?
No, I didn't. I didn't. Maybe they think when your house, because even before the castle doctrine, if you had a guy breaking into your house and you shot him, killed him, grand jury wasn't going to indict you, whether it said so specifically in the statute or not. I mean, they just weren't. Maybe they thought they needed to make it real clear when you could, when you absolutely did not have to retreat. That was always a sticking point for defendants in murder cases. It was always, should you have retreated before you shot the guy? Under any of these, under any set of circumstances. Basically, in the three situations they set out in the statute now, there's not even a question about it. The jury can't even consider it. Doesn't even come up. Before, the jury had to be charged. You had to say, hey, jury, would a reasonable person have retreated? If you think a reasonable person should have retreated before shooting, then he doesn't have self-defense, he's guilty. So, I guess they just felt like they needed to clarify house, business, and car, because I guess there's a lot more people just, I don't know that there are any more people getting caught up in the act of a burglary at their house or their business, but there are a lot of people being accosted in their cars.
Right. Now in the cars, okay, say we've got Woodlands Mall, you get a carjacking. So, woman's walking, got her purse, walking in her car, getting in the car, and halfway into the car, and some guy walks up and tries to get in the car and take her car.
Says if he's doing it unlawfully with force, you can shoot him.
Force being, I mean, strong arm or weapon or otherwise?
Force is probably going to be defined like pain in the aggravated assault and assault cases. Pain is if you hurt. That's about the extent of it. So force is going to be, you use force when you rip a lady's purse off her arm, for example. So I don't think they mean, they're not welcome in your particular space where you are in those three enclosures.
Right. Okay.
If you invite somebody in your house and you get in an argument and you shoot him, chances are you're not going to be entitled to any of this.
Okay.
Because you asked him in. He wasn't in possession of a firearm or anything like that. So your response with deadly force is not justified.
Okay. Now, like we were talking about impersonation, something that does that matter day or night there? Just that really doesn't have a bearing on day or night.
Which one?
Saying, for instance, like we were saying, if something would happen, say Woodlands Mall or one of the malls
No,
with the.
No, not under. I guess it applied in the old law. It wouldn't apply here. It doesn't say anything about it. If you occupy.
So if someone in daytime or nighttime tried to forcibly take your vehicle or whatever, you the right for deadly force. Okay. All right.